All right, Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court. Counsel. Good morning. Mr. Shorter and Mr. Russell were part of the crowd that encircled Richard Doffenbaugh. When Kent Tyler punched Doffenbaugh and sent him to the ground, Mr. Shorter and Mr. Russell were part of the crowd that was cheering and laughing and taking turns jumping into the air and stomping on Mr. Doffenbaugh. He didn't lose consciousness immediately, but he had to lose consciousness at some point before the blow to his abdomen tore his mesentery, which is the blow that caused his death.
Is there any evidence to suggest that that Shorter engaged in assault prior to the blows to the abdomen that caused death? I mean, that was what the Court of Appeals was relying on sequence, and I'm just probing that to some extent. And it seems to me you did have evidence that he kicked, but you didn't have evidence with respect to time. But perhaps I'm wrong, and I'm interested in your view on that.
So in terms of timeline, what we had is evidence that at least one participant had to stomp or kick Mr. Doffenbaugh in the head as he lay on the ground.
Maybe, but I'm concerned about Shorter for now.
Yes.
And then I have another question related to the collective kicking. But is the Court of Appeals right that there was no evidence that Shorter, at least, engaged in an assault prior to the death blow?
You're correct that the evidence showed that Shorter and Russell also both engaged in individual assaults. There was testimony that they each stomped on Mr. Doffenbaugh's face. The timeline isn't established specifically that those happened before the lethal blow, but joint criminal conduct can be shown by showing participation, i.e. aiding and abetting the initial assault. That in prong two, as the jury was instructed, aiding and abetting that assault, the blow to his head as he lay on the ground. That is participation in the predicate offense of assault, that vicarious liability for the different crime of murder when the fatal blow is inflicted.
Maybe this timeline isn't the right analysis, but if the assault, let's just say hypothetically, the assault that Shorter did was the last kick. I mean, let me just assume that hypothetically.
Sure.
Does that make him an aider and abetter of events that occurred prior to the kick?
In itself, no. It can be used as circumstantial evidence to infer earlier participation. But that participation earlier, I think, is most strongly shown by active encouragement of the acts as they occurred.
So Shorter might have liability for aiding and abetting the death blow, if you will, if it can be shown that prior to the death blow, he was engaged in celebratory acts of some kind, or anyway, engaged in some kind of acts that encouraged the subsequent act.
And I'll go even beyond that. I would say that if Mr. Shorter was actively participating and actively encouraging the assault that rendered Mr. Doffenbaugh unconscious, the blow to the head, that is the predicate crime on prong two of joint criminal conduct.
Maybe. Okay, so what evidence do you have of Shorter early on, if you will, aiding and abetting?
So he's in the crowd. Brianna Billings placed him in the crowd before the punch was even thrown. Then Mr. Doffenbaugh lands on the ground. Monica Perkins testifies that Shorter is one of the people who stomped on Mr. Doffenbaugh's face, participating in that same.
But we don't know when. I mean, he was in. So you've got him in the crowd maybe early on.
And we've got him as one of the participants who Monica Perkins described in the aggregate as laughing like it was a game, taking turns jumping into the air and stomping on Mr. Doffenbaugh's face. We have all of these circumstantial indicia of participation that the jury is entitled to weigh in determining whether they believe that Mr. Shorter participated in an assault. Now, I want to make sure I emphasize that if the Court of Appeals is right that this is just one long assault turned murder, then if any juror who used this joint criminal conduct instruction would have just made findings that showed aiding and abetting that second-degree murder. This is a case that falls under the Jackson exception, where there is no opportunity for Mr. Shorter or Mr. Russell, for that matter, to have been found guilty based on anything other than their own conduct as principal or aider and abetter, if the Court of Appeals is right that this is all one assault.
Let me try and, I mean, maybe I'm oversimplifying the analysis here, but let me try something out. I mean, let's take assume a different case. You have just Mr. X and Mr. Y, and together they beat some guy to death. Not the facts of this case, but assume that case. And witnesses are there and see it happen and see that they both delivered blows and the person was fatally beaten. Now, nobody can pinpoint who delivered the fatal blow and who delivered which blow between the two of them. That doesn't mean that you can't prosecute them under the three different theories we have here, does it? I mean, if the Court of Appeals is right, you wouldn't be able to prosecute that case, right?
You're entirely correct, Your Honor, that all three of these theories would be submissible in that case. I also want to point out that the resistance to our application for further review makes this claim that the state should have been more strategic in its charging decisions. If you look at the closing argument that Mr. Russell's counsel delivered, that's going to be on pages, I'm specifically referring to pages 948 and 949. Counsel says, if Mr. Russell participated, he only stopped Mr. Doffenbaugh's face or head or maybe his shoulders, and that's not participation in this murder. The state can come back with this joint criminal conduct instruction and say, under the law, that's not a defense to this murder. If you participated in the earlier assault and it's reasonably foreseeable that the different crime of murder is then going to be committed by one of your co-participants, that's joint criminal conduct murder. The state gets to charge these in the alternative because the jury could disbelieve participation in the later murder, but find participation in the assault. And under the law, that's murder.
Go back to Justice Mansfield's question. That's I think what I'll call the Paroline issue, I think. And there's some language, at least in Paroline, that talks about a multiple assault of some kind. And a multiple assault occurs, we know there's 10 people. Here 10 to 15, 8 to 15, whatever there are, and there's multiple people involved. And Paroline, I suppose, kind of suggests that we don't engage in granular analysis at that stage, and that there's even language saying the causation requirement is relaxed, I think, to some degree in that setting. Is there any case law in Iowa that kind of adopts that view? I mean, causation is kind of a critical element here, as you know, and in Tyler we talked at great length about causation, but I'm wondering if, I mean, the defendant and the Court of Appeals insists on what I'll just call a more granular analysis, that we just can't impose criminal liability for a more generalized conduct. So I guess my first question is there Iowa authority supporting the Paroline approach? And if so, why don't you again briefly rebut what the defendant's position is, that we just have to be more granular before we do a 50-year sentence on someone?
So based on what this court said in Tyler, more of a focus on but-for causation in the context of determining criminal liability, I think that alone is sufficient to carry this case. To the extent, I do think that there is a need for some clarification when it comes to multiple independently sufficient but not indispensably necessary causational factors. So if to use this hypo, X and Y each fire a shot out of a gun at the same time, both of them hit the victim in the heart, who caused the murder? There's room for some clarification on that.
But there you've got, you have equal acts. I mean, under your hypothesis, I mean, they shoot the gun. They're equally culpable. They're exactly the same, and we just don't know which bullet hit. One went high and one hit.
Well, no, in this hypo, both of them hit, right? But neither of them is a but-for cause of the death. But from the Paroline and the third restatement of torts approach, you can't escape liability just because there are other independently sufficient causes of death.
It strikes me that this is going to be common. If you have not the Summers v. Tice example, but the where you have kind of a gang or a group or a collection of people beat somebody up and then the person dies, then you're never going to be able to identify in many cases who actually delivered the fatal blow, and this would be kind of an insuperable bar to prosecution, wouldn't it?
You're right, it would, and I think that if we reject that Paroline and third restatement approach, then we end up in a situation where nobody could have been charged for Doffenbaugh's death. And I don't think that we can tolerate that.
Well, Tyler could be charged. Tyler was at the front end, and in Tyler we talked about it was kind of like, let's go get him. And he threw the first blow, and then
I still don't think that we should accept an outcome where none of the participants in the stomping and kicking could be charged for Doffenbaugh's death. I think that the law rightly contemplates that they are criminally liable for the results of their actions here. I want to turn really briefly to just to the proof of, so I want to analogize to Saturn, because there was some discussion in the briefing of this case of, was this murder really a crime in furtherance of the assault? In Saturn, there was aiding and abetting OWI as the predicate offense that triggered joint criminal conduct. The driving itself, hands on the wheel, foot on the pedal, that act remained the same throughout the entire commission of the OWI. When a different prohibited result occurred, when a person was killed, then it became the different crime of vehicular manslaughter. And so I think that that's exactly analogous to what we have here, is that the acts of assault, I would submit that each of those kicks and stomps is itself an assault. What the district court said below, and I think this is on page 176 of the appendix, is no matter what, there's at least two different kinds of serious injury here, or kinds of injury. There's the blows to the head that caused the unconsciousness, then there's the blows to the abdomen that actually caused death. So there's at least two assaults. May have been the same type of conduct for each assault, but then when a new, different prohibited result is committed, establishing a different crime of murder is committed.
We've got those cases that we decided a couple of years ago where somebody kind of is beating on another person and they're delivering multiple blows, and we talk about breaking the action and all that. But those involve one person. It seems to me when you have multiple individuals beating up on somebody, and that's what the evidence indicated here, you have to have multiple assaults, right?
I think that's exactly correct. And I'd say that if this was all one person, it would still be separate acts under Velez. But since we have so many different, for each participant, each person is doing a new act of assault. And that's the kind of unit, I guess, that the jury was given. An assault was defined as a person does an act that causes injury or instills fear of an imminent injury. And I don't think that we have the unit of prosecution problem here that this court alluded to in Tyler. There's no attempt to separate out the fear of the imminent blow from the blow itself. This is multiple assaults that are all happening from multiple blows causing injury or pain. And so we have those multiple assaults. I think that shows that there's sufficient evidence here to submit the joint criminal conduct instruction, and I think that alone resolves this case without discussing Jackson or Smith.
Ask this question. If the record showed that Shorter was not a participant early on, but walked up toward the end and kicked him to see how down ball was, would that give rise to aiding and abetting liability for the entire transaction?
So before I answer that, I'd reiterate that this is still a sufficiency challenge. We're always going to view the evidence in the light most favorable to the verdict.
Sure, I understand that. Yeah.
I think that if Shorter's conduct can't be characterized as participating in an assault, then you can't get joint criminal conduct. If he's not participating in the murder, so if that's not active, I brought the definition of participation just in case this happened. If this isn't an act done towards the commission of the murder, then you can't find him guilty of aiding and abetting the murder. If this isn't actively encouraging the acts that caused Mr. Doffenbaugh's death, then that's not aiding and abetting the murder. And I'd also point this court to Countryman, where there were alternative theories submitted there, both aiding and abetting and joint criminal conduct. And the court said, the evidence, as we see it, is sufficient to support the aiding and abetting conviction for murder through the aiding and abetting theory. But the state's also entitled to submit the joint criminal conduct instruction because A, it's submitted by an alternative, or it's supported by an alternative view of the evidence, and B, the jury may not believe that there was active participation in the actual murder. The jury may find on this evidence that there was participation in an earlier crime, but not aiding and abetting the murder. And the jury is always entitled to believe or disbelieve certain parts of the state's case and the state's evidence.
But that brings us back to Justice Appel's earlier question, doesn't it? You referred to the earlier crime. Tell me why it's anything more than speculation in this case to conclude that Shorter jumped on the victim's head after, or before or after, somebody jumped on his midsection and caused the mesentery damage, which led to his death.
And I see that my time's expired. Thank you very much. So I think that it's undisputed, or from this evidence, somebody had to stomp, at least one person had to stomp on Mr. Doffenbaugh's head before the abdominal damage was even possible.
Why?
And
why do you say that?
because he was, the evidence, or at least there's evidence supporting the idea that he was conscious when he hit the ground. There's BB's testimony on page, I'm sorry, from TT's deposition that was read, pages 33 and 34. Mr. Doffenbaugh was moaning and groaning after he hit the ground. Okay. Latia Schumpert said that she saw Mr. Doffenbaugh reach a hand up from the ground while he was surrounded, saw him reach up from the ground. There's evidence supporting the idea that he was still conscious on the ground, and that means there had to have been some assault to his head to render him unconscious at the point where Mr. Shorter and Mr. Russell were both participating in that assault. And that, I think, is the view of this evidence that the state argued and that supports the joint criminal conduct instruction. Thank you.
Mr. Sloven, thank you as well. Ms. Bonzer.
May it please the court? Mr. Sloven? Granting further review in this case, I think provides this court with a unique opportunity to clarify the three issues of liability, taking into consideration the Tyler facts and the facts that are before the court today. I'd first ask for the court's indulgence in discussing principal liability because just like the court in Tyler reconsidered the principal liability, I think the court should also look at that in this case. What I would suggest to the court is that what carries the day in Tyler while there's principal liability is a court can look at a but-for analysis or would the harm have happened in determining that, you know what, if that first punch wasn't thrown, this wouldn't happen, whether or not it's a but-for cause of the harm. I would suggest to the court that when the court looks at Shorter and when the court looks at Mr. Russell, that if Mr. Russell or Mr. Shorter, if they got a bout of the stomach flu, if they just happen to not be at that bridge, can the court look and say, would this not have happened?
Well, let's address what I call the Paroline problem. I may be mispronouncing the case, but it's a multiple assault. Not clear who delivers the death blow. Clear that the result is death. I think the state's position, if I understand it correctly, as well. I mean, he was there. He was one of the 8 to 15 people. There were repetitive kicks. We don't engage in what Justice Hecht and I were kind of probing around a little bit in this timing, and the Court of Appeals rested on timing largely. Why isn't it right that where you have multiple assaults, liability ought to extend to all participants in that? And maybe he didn't kick the mesentery, but he was certainly aiding and abetting those that did by encouraging, by being part of this, kind of raucous group.
What I would concede to you is that this case is the strongest theory of liability, joint criminal conduct, principle, or aiding and abetting, that this case is the strongest for aiding and abetting. I'm not conceding that the court should affirm based on that. I think the court should look, and I'm sorry for interrupting you, I think the court should look at the witness testimony and decide whether or not, in the light most favorable to the state, the state has proved beyond a reasonable doubt. But if the court does, if the court says the evidence is sufficient to link that tap to the hit to the head, given there's timing issues, that you've got aiding and abetting, that you have a mass brawl, if you can tie 50 people to a mass brawl of an assault, that it doesn't matter who carried that fatal blow, that it's aiding and abetting. But taking a step back from the aiding and abetting as to whether or not it's a principal liability and whether or not there's joint
It
criminal
may
conduct.
not be principal liability, and I think the state might even concede that that might not be its strongest case. But on aiding and abetting, they do have, I think, and I know you'll correct me, but they do have your client as one of the people crowding around. They do have, kind of cheers going up of some kind. I mean, the evidence is they're stomping as if it were a trampoline, and there's some levity about it, apparently. And the state has put Mr. Shorter in that small group. Is that sufficient to infer that Mr. Shorter is participating in this larger group event that includes stomping or whatever? And it may well be he was the last kick, let's just say. But he was still part and parcel of the transaction, and doesn't that make him aiding and abetting the assault?
If you take in the light most favorable to the state, conditioning the problems with Ms. Perkins' testimony, conditioning the problems with,
We're gonna construe that most favorably to the state. I mean,
Right.
Perkins has all kinds of problems. Maybe he cross-examined her, and it looks like the jury perhaps credited her.
right. But if you take that kick to the head that Ms. Perkins testified to as true, I think you've got active participation for an aiding and abetting theory. My concern is the principal liability and joint criminal conduct, that it just doesn't carry the day on those theories of liability. And then we have the same problem as Tyler. We have a general verdict where we don't know where the jury found what
What do you make of
liability.
Jackson, then? Jackson's an interesting case, is it not? So share with me your thoughts.
My thoughts on Jackson is that it was from 1998, and that the court has further clarified this via Smith, also via Tyler, and that when we're talking about a case indicating Jackson where it's a hitman situation versus a case where the state's first argument on further review is that this is an assault and that the second crime is a murder. So they're arguing that, and then they're arguing a Jackson exception. So they're arguing, one, that this is joint criminal conduct based on an assault and then being a murder, and then they're arguing some sort of a Jackson exception, that there's no way that the jury could have found this way.
Yeah, but
that-
let me share what I think the state's argument is. The instruction for joint criminal conduct had what I'll call the predicate offense as an assault. It may well be that the particular kick of Mr. Shorter occurred after the mesentery damage. But the theory of assault is that he was aiding and abetting the assault from the get-go. And if that's true, then the jury must have found an assault. And if they must have found an assault, he must have aided and abetted, and therefore, there's no problem with this instruction.
My concern is that with Mr. Shorter, we have witnesses tying him to a touch with Mr. Donbaugh. But what other information do we have about Mr. Shorter actively encouraging or abetting this assault or this surrounding? I think that it's just based on speculation. And I would also suggest, and I know that this court has already brought that up, but the timing issue as to where and when Mr. Shorter became involved, that it just doesn't carry the day when we're asked to speculate when in fact this particular touch happened.
We already said in the Tyler case that striking the blow could constitute, that was sufficient evidence to get to the jury on aiding and abetting of the subsequent murder. I'd like you to examine that hypothetical I was asking Mr. Sloven about. So say you just have two people delivering blows. There's one victim, he's beaten to death. Witnesses say both of the individuals delivered blows. Nobody can pin down the sequence of who struck when. What theories can you go to the jury on against those two individuals?
I think clearly you can go to aiding and abetting. Joint criminal conduct.
How do you know that one defendant might have just delivered the last fatal blow? That person did that person aid and abet?
So you're saying the timing issue as to, we don't know whether there was an agreement in the first place, or?
I'm sorry, I interrupted you. Keep going. I want to hear your answer on the other
Right,
theories.
right. I guess my understanding from when you had explained that, I had understood it that it wouldn't just be two, random events where they, two people had not reached some sort of an agreement to target this specific person. I see what you're pointing out with principal liability, that I would be standing up here arguing, who was the but-for cause. But I would suggest to you that almost any time when you have two people that are deciding to shoot at somebody or to deliver some sort of a blow to somebody at the exact same time period, that there's going to be some sort of an agreement, which is going to end up to be an aiding and abetting theory.
But I mean, is it really the case that you need to have evidence specifically showing that the defendant was a principal and as opposed to an aider and abetter to get to the jury, or do you just need evidence that would support any of the three theories?
What I would suggest to you is that Judge Tabor pointed out in oral arguments, isn't this a case where the state should have just been more selective in their charging decision? And I think that this case carries the day on the aiding and abetting theory, and that the decision of sorting this out, these are some difficult issues to grasp. Taking these hypotheticals into effect, these are some difficult issues for me to understand, as I'm sure that these are some difficult issues for you. And to take this away from the prosecutor who should be making these decisions, and to require a layperson, a juror, to sort these out without any judicial overview, as the state is suggesting with the general verdict form, I think that that's troubling.
Are general verdicts in this situation a bad idea? Should the jury be instructed to identify which theory it finds?
I think that what the court's ruling on Tyler has made it pretty clear that any time as a prosecutor you decide to charge a case under liabilities, that the prosecutor, the judge, and the defense attorney should be requiring a special interrogatory so that it's subject to review. And that way, if that would have happened here and the jury would have said, what, we find it under all three, I think the court could still carry the day with the aiding and abetting instruction, assuming that I think that that's the strongest theory.
Is there a possibility factually that your client was convicted of for something he did not do?
Yes. I think that this presents the same problem as a person that's overcharged that is particularly culpable. You have a client that definitely committed a robbery second, but the robbery first is not quite there. For whatever reason, it's not a dangerous weapon or a serious injury. Jury doesn't like the facts, and they go back there and they find him guilty of the robbery first. Well, under that type of situation, this court, or the Court of Appeals, has that opportunity to review the evidence and to decide whether or not, in the light most favorable to the state has met its burden. In this case, when we have these three different types of liability and a general verdict, the court is not granted that indulgence. Mr. Shorter is not allowed to present that to the court because we don't know what happened. As far as the joint criminal conduct, I would really ask this court to reiterate or to think about the timing issue. I know that was discussed with Mr. Sloven, but I would point out that my review of the record, I don't see anywhere where we can push to some sort of timing. I would concede that Ms. Schupert's testimony, that Ms. Perkins' testimony, and that also as far as the statement to my client that he made to Detective Peake about some sort of a nudge or that there clearly is a touching that happened, that the state can tie that pursuant to that testimony. But as far as when this touch happened, as far as when this happened, whether it was the last time or it was the first time, whether or not Mr. Doffenbaugh was conscious, whether or not he was laying down, or whether or not...
Ms. Bonzer, as I understand your position, I mean, the Court of Appeals upheld aiding and abetting in principle, said insufficient evidence on joint criminal conduct. What I'm hearing you say is insufficient evidence on principle and joint criminal conduct, sufficient evidence on aiding and abetting. Am I right?
Conditioning my arguments on the light most favorable to the state.
And your argument is there's no witness that directly can say on the principle. Your argument is you have to have a witness that would directly say that Shorter, as opposed to everybody else, delivered the blow that tore the mesentery.
I recognize your comments about the two people the very same time, but I would also suggest that getting there, versus where Mr. Tyler was, which, set into the motion this chain of events, and then to where Mr. Shorter was, or even Mr. Russell, if they just happened to walk away, I don't think that it's anything other than speculation that would have changed anything. So I guess I recognize that your hypothetical, it presents a unique issue as to liability, but I don't think that that's what we have here. But yes, so to reiterate, I would ask the court to consider as to whether or not the state's evidence in this case, the challenges that were made on cross-examination as to identification. But I would also ask the court to reverse and remand this for judgment of acquittal. I would also strongly urge the court that this is not a joint criminal conduct case, that this is not a principal case, and that the case should be reversed and remanded for a new trial. Thank you.
Ms. Bonzer, thank you as well. Mr. Sloven, you may present your rebuttal.
Thank you, Mr. Chief Justice. May it please the court, counsel. I think the legislature already expressed a view on this problem of what if everybody is aiding and abetting. We have section 703.1, which says when participants are charged with participation in an offense as aiders and abettors, they shall be charged, tried, and punished as principals. I think State versus Black also supports that. Even if it's just aiding and abetting, we have to give the principal liability instruction. And I also do think that the evidence is sufficient to support a finding of principal liability if the jury found that Mr. Shorter was inflicted one of the hits to the head that was a but-for cause of him losing consciousness, and then we have that. So I don't think I would love guidance on the Paroline issue. I don't think we need it to resolve this case. The Court of Appeals certainly didn't. I want to answer Justice Waterman, I think it was your question. Is there a chance, factually here, that Mr. Shorter was convicted for something he did not do? And the answer is no. The jury specifically found, if they used the joint criminal conduct instruction, the jury specifically found that Mr. Shorter and another person or persons knowingly participated in the crime of assault as it was defined for them. And they were also—
That could include aiding and abetting, I take it.
I'm sorry?
I take it that could include aiding and abetting an assault.
Well, yes, exactly. That's exactly true. So what this means is that if the Court of Appeals was correct in its analysis, if it said the state's wrong, there aren't multiple assaults here, there's just one assault turned murder, that means that the jury found Mr. Shorter participated in it. Factually, there is no chance that Mr. Shorter or Mr. Russell were found guilty based on something they did not do, based on some set of facts where they didn't participate in what the Court of Appeals called a single crime of murder. I think that embodies the Jackson exception as it applies here. I also think this court doesn't need to go even there if it believes, as we discussed before, that there are more than one assault committed here to sustain the joint criminal conduct instruction as it was given. I think that I didn't hear any real—
Except, I'm sorry to interrupt you, but except in Smith we made it clear, it seems to me, that there's a predicate crime and a resulting crime. And in order for joint criminal conduct to be present, you must show a prior crime, and the latter crime is in furtherance of the earlier crime. So if the evidence showed that the assault occurred and the aiding and abetting occurred after the death blow, it wouldn't work. Your position, if I understand it right, is although we don't know for sure when the kick happened, we do know, or you say there's sufficient evidence to support aiding and abetting at the get-go, I guess, when they're part of the collection of 10 to 15 people or whatever. Please correct me if I'm wrong, but
I think you're exactly right that there's sufficient evidence to show aiding and abetting that initial round of assaults right when he hits the ground. That's how the state argued this in closing argument. Right when Mr. Tyler throws the punch and these three jump in, they're participating in that assault. Now, if that is a separate assault from the later different crime of murder, which I think it is, or if it's all part of the same crime of murder, that's participation in it. Smith reanalyzed the Jackson
Court of Appeals
exception.
is really kind of inconsistent. On the one hand, they said there's sufficient evidence of aiding and abetting, but not sufficient evidence for joint criminal conduct. What you're suggesting is they should have linked the two arguments.
In the Court of Appeals?
Yes.
Absolutely, I think. I think that the big problem with this is a failure to apply the Jackson exception. I do think that there are two separate crimes. The failure to apply the Jackson exception, even Smith applied the exception and said, is there an opportunity here under the facts presented for the jury to have wrongfully imputed vicarious liability when it wouldn't have been, if this joint criminal conduct instruction was given erroneously, did that misstate the defendant's culpability in any way? Is there an opportunity for the jury to make findings that lead to a wrongful imputation of vicarious liability? And I really just don't see any of that on this record. If the jury convicted on a joint criminal conduct instruction, and if this was all one crime, Mr. Shorter and Mr. Russell both participated in it. The jury was required to find that to use this joint criminal conduct instruction. Nothing that I've heard or seen in the entire briefing of this case has led me to believe that there's any possibility that either of these men were convicted based on anything other than their participation in an assault that preceded the murder or the assault turned murder itself.
And under that analysis, it does not matter whether their blows to his Doggenbaugh's head came before or after the fatal blow to the abdomen.
As long as they're aiding and abetting assaultive blows that occur before the blows to the abdomen, that supports the joint criminal conduct instruction. So it's not entirely necessary to find that Mr. Shorter himself, for this, if they do find that Mr. Shorter himself inflicted or committed an assault or inflicted an injury before the fatal blow, you can find but-for causation for principal liability. If you don't, in the alternative.
One last follow-up. I think it's germane to what you just said, though, but our case law does suggest that mere presence isn't enough for aiding and abetting.
Absolutely true, and the jury was instructed to that effect. And they acquitted co-defendant Williams, who admitted he was there.
But do you have sufficient evidence of the aiding and abetting if all you have is his presence in the group prior to his kick?
We have his presence in the group as part of the crowd encircling him. We have Monica Perkins' testimony as to the group's conduct of cheering, laughing, taking turns, treating this as a game. We have his subsequent conduct from which you can infer his earlier participation, regardless of when the kick happened. I think that it allows an inference of participation in the entire assault by aiding and abetting or actively encouraging it. And for those reasons, we ask this court to reverse the Court of Appeals.
What's the state's position on the use of an instruction that would identify the theory of guilt that the jury adopted?
I think our first position on it is that it was not requested in this case. I don't know if a defense attorney would ever request one because because what I'm envisioning from your question, Your Honor, is a checkboxes that all three of these theories are supported by the evidence. Check all that you can reach unanimously. If all three of those boxes come back checked, then you've cut off a useful avenue of appeal and all of these challenges engendered by this line of cases about general verdicts. So I don't see defense counsel requesting that because it can be so strategically bad for I could be wrong about that, but I don't see it useful. I would think so. I would think it would make this case a lot clearer. Not requested here, and definitely not in the defendant's interest to request.
Thank you, Mr. Sloven. The case of State versus Shorter is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.